everyone. Welcome to the last lecture of the class. So this is our last new material that you'll learn for the entire class. We're going to have an overview of the juvenile justice system. So this is chapter 13. We're just going to quickly provide you an overview. If you're really interested in juvenile justice, there is a juvenile justice course that you can also take that gets into much more detail. But I'm just going to provide you a general overview of the system for this class. Okay. So, going to talk about the juvenile justice system. So my first question is, what do you know about the juvenile justice system? Do you know anything? Have you ever learned anything? Do you realize that there's a separate system for juveniles? So I just was kind of wondering what you know about the juvenile justice system, if anything. Well, hopefully, if you don't know anything, you're going to learn a lot through this lecture. So one of the things that you need to know is there is a separate and distinct system for trying juveniles for crimes. So if a juvenile is accused of a crime, they go to the juvenile system. They're not always tried in the adult system. Now we're going to talk about sometimes when they are, but in general, they're always going to be tried in the juvenile system. So the question is, have they always had different systems? Has there always been a different adult system and juvenile system? And the answer is no, that it's sort of evolved over the years. Originally, a couple of states, Massachusetts, Rhode Island, New York, they decided they thought they should have a separate system. So they did have a separate system that they used. But in general, prior to that, juveniles were always just treated like adults. So they were always just tried in the adult system. It wasn't until in the later 1800s where they finally decided to create a separate system. Now, in 1899, they finally Illinois actually created legislation that created a very, very distinct difference between adult and juvenile court. And this Illinois Juvenile Court Act became the model for all states to follow and have them treated differently. And then pretty much after that, all states started to develop their own juvenile system. And then it took till 1938 until the federal system finally created a federal juvenile court system. So just a question, do you know what the New York State juvenile system is called? Well, in New York, we call it family court, okay? So what do you think causes juveniles to commit crime? So if you remember all the way back to the very beginning of the class, we did a section on criminology and the reasons why people commit crimes. And the question is, do you think the same reasons that exist for adults also exist for juveniles? And the answer is pretty much, yeah, pretty much the same things, the same reasonings of why people commit crime, classical school or sociological or philosophical, psychological theories all sort of apply to juveniles too. There are some additional theories of why. Sometimes it's parental supervision and things like that. But in general, most of the same criminological theories for adults also apply for juveniles. So then the question is, what kind of crimes do you think are committed? Well, when you look statistically at the type of crimes that juveniles commit, most are property crimes, public order offenses. So they are not as much into the offenses against persons. Sometimes they are, it's assaultive types of offenses mostly, but most of the time it's property or public order types of crimes. Public order crimes being like rioting or curfews or stuff like that, or disturbing the peace, disorderly conduct, those types of offenses, but a lot of property crimes. Now, when you're talking about juveniles, one of the things that you need to understand is the juvenile system classifies juveniles with different titles, okay? So these are the 6 main categories of how they classify juveniles. So the first one is what we call undisciplined. These are juveniles that the parents can't control. You know, maybe the parents give them curfews or tell them to be home, but they don't follow. They do whatever they want. They're out all the time. They skip school. They're not following the rules. Those are what we would classify as undisciplined, where you need the state maybe to step in and help enforce some of the parental rules and requirements. Dependent are juveniles that have basically been abandoned by their parents. So they are become sort of what we call wards of the state. The state has to take over for food, shelter, care, because the juvenile has been abandoned by their parents. Neglected. So we said parents generally provide food, shelter, water, schooling, clothing to their children. If children are not provided with those basic needs, that is considered neglected. Supervision, food, clothing, shelter, water, education, sending them to school. So if parents are not providing those basic needs, that is considered neglected. Abused. Abused is often the category that's used for multiple forms of abuse. It could be physical abuse, if the juvenile is being physically abused, psychologically abused, emotionally abused. Those are all fall under the category of abused. And then you have delinquent. And a delinquent is somebody that commits an adult crime. So it's a juvenile that commits an adult crime. So obviously murder, robbery, theft, any of those things. If a juvenile commits it, then they are labeled delinquent. The last category we have are what are called status offenses. Status offenses are offenses that are only crimes for juveniles. So there are certain things that we create laws for that only apply to juveniles. Curfew, truancy, which is requiring students to go to school. Things like that. You can't smoke, can't drink till you're a certain age. So those are crimes as an adult I can't commit because they're only crimes that apply to juveniles. So if the juveniles, they break the rules that are designed specifically for juveniles, these status offenders, they're labeled as a status offender. Those are status offenses and they're labeled status offenders. Just to test your knowledge on the different categories, you can read through these and think about how you would classify each of these. A child's beaten and sexually abused, a child that refuses to follow house rules, a child who's abandoned at birth, does not receive physical or psychological care, a child who robs a bank, and a child who commits the crime of truancy. So think through the categories and figure out which one they apply. Now I've created a practice assessment online. So if you want to challenge yourself and see which ones would they be, you can go online and take the practice assessment to test your knowledge on the different categories of juveniles. So the question is, when are you no longer a juvenile, and when do you become an adult? So at what age do you transfer from juvenile court to adult court? Well, it depends on the state. All states are different. They have different rules. The majority are when you turn 18, that is when you become an adult. And that is what it is now for New York. New York used to be 16 for a long time. And just a few years ago, they finally changed it to 18. First 17 for 1 year and then 18. So now in New York, you do not become an adult until you turn the age of 18. But you can see that different states have different ages. So then the question is, can you be tried as an adult even if you aren't 18? And that is an issue which we call binding over. So yes, there are certain circumstances that you are a juvenile under the law, you're under 18 in New York, but you can still be tried as an adult. So the New York law is very specific and provides for exceptions to certain laws where you can be taken from the juvenile court and tried as an adult. And we in New York save those for the most serious offenses, like the homicides and things like killing of people. But that is called binding over. You're taking them from the juvenile system and putting them in the adult system. You're binding them over to adult courts. Okay, so how do you make a decision of whether or not to bind somebody over? So who makes that decision and how is it made? Well, it depends on your state. Some states allow the judge to make the determination, some let the prosecutors make the determination, and some states specify it in a statute or in the law. Okay, so if it's a judge or a prosecutor, that's considered a discretionary choice by the judge or the prosecutor. If it's a statute, the law specifies that the legislature has already specified which crimes will automatically transfer you to adult court. Now, if it's discretionary, you want to think about what sort of factors would make a judge want this juvenile to be tried as an adult? What kind of things in your mind would make you go, oh, that is so bad, I think I want them tried as an adult and not a juvenile? Well, they consider lots of different things. They may consider the age. So there's certain restrictions of when you can be bound over. There's certain ages. If you're too young, they won't let you bind over to adult court no matter what. So age is a consideration. You may find a 17 or 16-year-old more likely to be bound over than a 10 or 11-year-old. Do they have a prior criminal record? Have they committed other crimes in the past? So they're kind of savvy to the system. And then how serious the crime. Is it a very serious crime, a crime against a person? They actually killed somebody, things like that. Those are all going to be factors that the judge considers or the prosecutor considers when making the determination of whether to bind the juvenile over. Now, the question is, can you just bind a juvenile over and just tell them you're going to adult court, or does that juvenile have to be offered a hearing, sort of like a little mini trial to determine whether they should be bound over? And this is one of the big cases for juvenile court. It's called Kent versus US. And the Supreme Court said that a juvenile cannot be bound over to adult court unless that they are provided with some sort of a hearing. So if the prosecutor or judge decide they're going to bind them over, they have a hearing where the juvenile gets to argue that they should be kept in family court in New York, the juvenile court system. And the other thing is juveniles are entitled to a lawyer during this process. So if a juvenile is going to be sent to adult court, they're entitled to the right to an attorney and their right to have a little hearing to make sure that they should be bound over and they can fight against it. Okay. So let's think about it. If you were a judge, what would you do? Would you bind over these people? So you have a 12-year-old boy who killed his 6-year-old friend while playing and imitating a wrestling move he saw on television. Would you bind that juvenile over? Think about age, seriousness of crime, previous criminal record. Do you think this 12-year-old should be bound over and tried as an adult? What about this? A 9-year-old boy puts the fire alarm on and waits outside the school and shoots the students and teachers as they leave the school. Clearly younger, but more serious crime in the sense that there was some premeditation and thought process behind this crime, some evilness behind this crime. So how do you think about that? Would you bind that person over? Or what about this? A 10-year-old boy who kills an opposing gang member, so they would be initiated into the gang. Would you bind that 10-year-old over to adult court? Now, sometimes when you read these scenarios, it's like, yeah, definitely, I would definitely bind that person over. But just to get you really to think about it, these are 10-year-olds. And this is a 10-year-old that you would be confining to adult system and basically giving them life in prison from this age for the rest of their life. So you have to really think about that. It's a really difficult choice to, especially young children. We're going to just treat them like adults at such a young age. So, we have some rules governing it because it's a pretty harsh sentence to sentence a 10-year-old to life in prison. Okay, so now that we've thought about it, let's think about what are some of the differences between the adult and juvenile system. So we have this juvenile system. How is it different from the adult system? Well, the biggest difference is what is their primary goal in this system. So if you are in the adult system, we've talked about over and over, your primary goal is justice. The whole criminal justice system is set up for justice, right? Well, what about the juvenile system? It's not the same. If a juvenile is in the juvenile system, the goal of that juvenile system is to determine what is the best interest of that child. That is not the same thing as justice. In justice, we're balancing both sides, right? And what is fair or just for both sides. Juvenile justice system, we're looking at the child who committed the crime. What is the best way for us to rehabilitate that child? What is in the best interest of that child? So we're not necessarily worried about justice or the victim. We're trying to figure out a way to rehabilitate the juvenile. So we think under the age of 18, you're still a child, there's still hope, we can rehabilitate you. And so when we think of goals for our system, we have to think through what is the best way we can reform or rehabilitate this juvenile and return them to a productive life within society. Another big difference between the system is the terminology. Since they're juveniles, we don't want to sort of taint them with this bad terminology. You're a criminal. So we came up with different terminology. So when you're talking about the juvenile system, they use different words. So instead of a criminal, you're a delinquent. Instead of having criminal charges, we just file a petition against you. Instead of booking you, we're just doing an intake process. Instead of a trial, we have an adjudication. Instead of a verdict, we have a disposition. And instead of sending you to jail or incarceration, we call it detention. So as you can see, the terminology between the two systems is very different. Again, what's the best interest of the child? How can we best rehabilitate this child? We're going to use different terminology so that we're not scarring or tainting or branding or labeling this juvenile for the rest of their life. The steps are a little bit different too. So you can kind of see this is the steps of the adult criminal system we've talked about, but in the juvenile system, it's a little different. You have an intake, which is kind of the booking, but it's more of a screening process. Then you could determine, are we going to hold this juvenile prior to their adjudication? And then we're going to file a petition, which is the charges, remember? And then we have the trial, which we call adjudication. And then we have different forms of correction. So it's a little bit of a different system. And again, different terminology for our system. Now, pre-trial, let's think about some of the procedures that are used by police officers and how those would change based on it being a juvenile. So the question first is, do police have to read juveniles their Miranda warnings? So we talked about Miranda warning, we talked about procedure law, and we said anytime somebody's in custody and being interrogated, they have to be read Miranda warnings. Do juveniles have to be read Miranda warnings? Yes. So juveniles have the same rules when it comes to Miranda as adults. They have the same rights as adults. Now, what about the search and seizure rules? Do the same search and seizure rules apply to juveniles? Do juveniles have a Fourth Amendment right to privacy? And in general, yes, in their everyday life, they do. But if we're talking about schools, schools are a little different. So juveniles are going to be in schools. We need to allow schools to have a little more rights to make sure that they keep all students safe. So remember, in general, in order to search, you need a warrant, you need probable cause. For a school, though, we're only going to say you need reasonable suspicion. So hopefully this is a flashback to your levels of proof. Mere suspicion, police can't do anything. Reasonable suspicion for an adult, they can stop, question, frisk. Probable cause, they can search and seize, arrest. Preponderance of evidence was the civil level. It's just 51% of the evidence and you win. And then beyond a reasonable doubt is like a 98%. And that's what we use to convict. So when we're talking about Fourth Amendment rights to search and seize, instead of probable cause to search for a school, we're going to reduce that down to only reasonable suspicion to keep schools safe. Now, adjudication, the trial. Remember, adjudication means the actual trial. So when you're talking about the trial, you have to think about what rights do juveniles have during this trial process, during the adjudication. What due process rights do they have? Well, one of the biggest, I said Kent was a big case. This case is even bigger for juvenile justice. What In re Galt says is that juveniles are entitled to basic due process rights, especially in adjudication. So they have the right to be notified what are the delinquency charges that are being placed against them. They have the right to counsel, so they have the right to an attorney during the adjudication process. They have the right to cross-examine witnesses against them, so it's just like a trial. And they have the right to ask the witnesses questions. And they have the right against self-incrimination, so you can't force them to talk. They have the Fifth Amendment right to remain silent if they want also. So those are basic rights that juveniles still have, even in the juvenile system. Now, what level of proof, though, do we need to find them delinquent? Well, we said for a criminal case, you have to show beyond a reasonable doubt to convict. Is it the same for delinquency? And the Supreme Court said, yes, still beyond a reasonable doubt. But with status offenses, remember, status offenses are those crimes that are only crimes for juveniles. Adults cannot commit status offenses. The Supreme Court said, if you are trying to find the juvenile responsible for a status offense, the prosecutor only has to show preponderance of the evidence, 51%. So status offenses are usually much lower level offenses, less punishment. So we're going to let a little bit lower level of proof in order to find somebody guilty of a status offense. Now, do juveniles have the right to a jury trial? So we know they have a hearing and adjudication, but do they have the right to have it be in front of a jury? The Supreme Court has said no, juveniles are not entitled to a jury trial. And that's just what it is. So the judge would make the determination beyond a reasonable doubt for delinquency or preponderance of the evidence for a status offense. Now, the next question is, well, what if you try them in juvenile court and they're found not delinquent? Can you then retry them in adult court? And we've talked about, I don't know how much we talked about this, but there's this concept, double jeopardy. You can't be tried twice for the same offense. So is that the same here? If you're tried in juvenile court, can they try you in adult court? And the court said, no, that is the same thing as double jeopardy. So you cannot, you have to make a choice. Am I going to try them in juvenile court or am I going to try them in adult court? Now, we've talked a lot about sentencing goals. What is the purpose of our sentencing? We just covered this in the last couple of weeks. And we gave you all kinds of goals that the adult system's trying to achieve: retribution, deterrence, incapacitation, rehabilitation, restoration. The sole goal for sentencing for juveniles is just rehabilitation. If a juvenile is in the juvenile system, our whole goal is how can we fix them and return them to be a productive member of society. So we are focusing on rehabilitation. So when a judge is making a sentencing determination, the judge has to consider what is the best way to rehabilitate this juvenile. So what are some options then that the judges can use? Well, they can be released to their parents. So that could be an option. They could be placed with a guardian if the parents were not properly doing what they needed to do or they don't have parents. Home confinement. You could use electronic monitoring, home confinement, so they're not sent to a facility. There's juvenile probation, just like adult probation. It could be a short-term detention, almost a shock incarceration, put them in for a little while and then let them go. You can have juvenile confinement. So you're actually placing them in a secured facility, just like a jail, but for juveniles. And don't forget, we can bind juveniles over to adult court. And if they are, then they can be placed in adult confinement, adult prisons. Now, when you're talking about detention, when you're talking about putting them in in some sort of a lockup or a program or requiring them to go somewhere, there's different types of detention. There's what we call non-secured. So this could be like a drug rehab program or requiring them to go to a certain school or certain activity, but there's no police officer following them around. They're not locked up. But we do have certain secured placements. So we do have special jails that are designed specifically for juveniles. We call them juvenile detention centers. They're secured. They are locked. You don't get to go where you want when you want to go. Usually they're saved for the worst of the worst juvenile offenders. They're very similar to adult system. This just is a statistics that kind of shows you how many are locked up and where they're placed and what types of facilities that they're placed in. So if you're interested, just some statistics. Now, within corrections, we have solitary confinement. Sometimes individuals are placed in a solitary confinement cell where they have to stay isolated for a certain amount of time. So the question is, should we be using solitary confinement for juveniles? The mind is not developed yet. Your brain isn't fully developed until 25. So you're talking about extreme isolation, extreme conditions. What is that doing to your mind development? So in recent years, there's been a big push to ban this in for juveniles, and it's banned at the federal level. There's no use of solitary confinement for juveniles at the federal level at all. And many, many states, including New York, have banned it for juveniles. So let's put some of these concepts into play. You are the judge. You are going to have to sentence a juvenile. When you are sentencing them, you have to keep in mind what's the best interest for this juvenile and how can I rehabilitate this juvenile. So if this was your example and you were a judge, Jared Owens, 17 years old, is a dropout, convicted of 2 burglaries, is a criminal record for 3 other crimes, 2 shoplifting and a theft. His parents are frustrated and admit having trouble controlling him. His 2 brothers are well-behaved and have no criminal record. So you are the judge. You have to go through that process. What is in the best interest of that juvenile? It's still a juvenile. It's not a serious enough crime to be transferred to adult court. You're in juvenile court. What is best for this juvenile? What we are going to rehabilitate this juvenile? What is the least sentencing option we can use to rehabilitate and make this juvenile's life better? We're always going to go to the least. We're not going to say, oh, just lock them up. We always have to think through what's the least punishment and move up until we reach the one that is appropriate to rehabilitate and best interest of this juvenile. So those are the types of things you have to think through. And remember, sentencing is discretionary, so the judge has some discretion. So you may all have different answers, but you would have to think through those 2 standards, best interest of the child and rehabilitating the child. Now, what about this? Annie Yearns is 15 years old, is convicted of attempting to steal a car. It was her first offense. However, she's a runaway. 2 prior occasions, she ran away from her father. The first day she came back, there were 3 days. The second time they brought her back, she was there a week. She claims she stole the car to get away as far as possible. The father did not attend any of the intake or dispositional hearings, isn't part of this at all. So now you're a judge. What's in Annie's best interest? What's the least sentence we can give her to help rehabilitate and reform her and turn her into a more productive citizen? What's the best interest for Annie? So again, those are the things that you have to think about. So that is your overview of the juvenile system. So what do you think? Do you like the juvenile system being separate, or do you think that they should just be treated like adults? Do you like having the best interest of the juvenile being the purpose of the judge, or do you like it to be just justice? Do you think the sole goal of the juvenile system should be rehabilitation, or should we have retribution and deterrence in the juvenile system? So those are some things to think about with the juvenile system. So hopefully you learned something about the juvenile system more than what you answered at the beginning of the lecture. So that is your last lecture for the class. I have very much enjoyed lecturing you this semester, and I hope you've enjoyed the class and learned a lot. I will see you soon.